Welcome to a special episode of GRL Raw from a different conference room.
Call it extra raw.
Extra raw.
Unprofessionally produced, but professionally produced nonetheless.
And today we are going to talk about the Trump indictment. Trump was indicted with 34 felony counts 2 days ago.
I believe so.
Yeah, and was arraigned in Manhattan. And we got the indictment immediately in the statement of facts as soon as it was released. And we decided to go through it, and we're going to do some lawsplaining.
And we came up with a definition of lawsplaining.
Oh, he came up with the definition of lawsplaining.
It is the breaking down of over-fancified legal mumbo-jumbo, so all may understand.
I like it.
I do too.
I
came up with it, so I have to like it. But we went through the indictment. We went through the statement of facts. We actually went even further and got into the Michael Cohen case. We pulled the transcript of his guilty plea to get the exact words coming out of the horse's mouth.
Yep.
Because they're all interrelated with the Trump indictment. So what we want to do is be as concise as possible. We are going to give the clearest, simplest, most understandable explanation of the Trump indictment and what the facts are that they're claiming support it, and then what the law is that the prosecution is going to have to prove. First things first, what is an indictment? People want to know what the hell is an indictment.
An indictment is the charging instrument. Your definition is legal mechanism of bringing a criminal accusation against someone by way of a grand jury, but it is the actual document of charging.
So it's here, you were officially charged, be noticed, come into court, and we start the process.
Yep, you're going to face these criminal charges.
And what's the requirement for somebody to be indicted? Like what's the standard?
Probable cause.
Which we've talked about in the past.
We have.
It's a ridiculously low standard. It's what's required for a police officer to pull you over.
Yep.
So it's reason to believe an offense may have been committed.
Yep.
Proof beyond a reasonable doubt isn't necessary. You're not even getting there. It's simply somebody raising their right hand and saying, this is the accusation.
Yep.
So it's nothing more than an accusation.
Nope.
All right. So let's get into it in a nutshell. The basis of the charge, of all the charges, is surrounding really one situation.
Yep.
Which is?
Michael Cohen paying hush money to Stormy Daniels before the election and documentation that was allegedly falsified after and before the election, which makes up the 34 counts.
So all these 34 counts can be summed up with the basic factual allegation of Michael Cohen acting on Trump's behalf.
Yep.
During the 2016 election campaign, paid $130,000 to purchase the exclusive rights to Stormy Daniel's affair story. And then there was supposedly a subsequent agreement after Cohen had paid the hush money, entered into between the Trump organization, CFO, and Cohen.
Yep.
Where Cohen was repaid a total of $420,000 for his advanced expenses and work keeping people quiet.
Yep.
And then what happened is the claim is that he would submit a request for payment to the Trump organization under the retainer agreement. Yep. And then the Trump organization and/or Trump, 12 separate payments of $35,000 each. And they categorized those payments as legal expenses.
Yep.
So we have one count for every payment and every business record entry claiming that the payment was made for legal expenses. Yep. Okay, so that's what pretty much, that's as simple, but that's what they're basing the charge on.
Yep.
All right, not as salacious as we had hoped.
No.
It's kind of a letdown. So the law then, what is it? What is the law? What is he accused of? What's the law they're claiming he violated?
So they're charging him. It's called falsifying business records in the first degree, and the elements of the crime require that the defendant, with the intent to defraud, makes or causes a false entry in the business record of an enterprise prevents the making of a true entry or causes the omission thereof in the business records of an enterprise. And also they have to have the intent to defraud, including an intent to commit another crime or to aid in the concealment of the commission of the crime.
So and that's what makes it the Class E felony,
Yep.
correct? Okay,
Yep.
So the first part is with the intent to defraud makes or causes the false entry in business records of an enterprise. The other one we had down there was another alternative that they could charge, but still requires intent to defraud. But then what makes it a felony is doing this with the intent to commit a separate crime or aid or in the concealment or commission of another crime.
Covering up someone's crime, your crime.
Yep. And so and before we get to the important distinctions here, though, a good example of it when we were looking through this would be, for example, with government aid.
Yep.
Right. So the recent employment retention credit, it would be like a business falsely creating an additional employee record to either obtain a larger tax credit or after submitting the request for the extra tax credit, claiming an extra employee, adding records after the fact to try to make it look like they had an employee.
Yep.
That would be a classic example of this.
Falsifying business records.
Correct.
Yeah.
Correct. I think it's important to understand that Trump himself, the individual, Donald Trump, is indicted. He's the one charged.
He is.
So they have to show he's the one that was involved in this process.
Yep.
He had a direct connection to it.
He either falsified the documents himself, pen and paper, or he caused them to be falsified. That's what they have to prove.
In other words, instructed, directed, or otherwise assisted in the falsification. All right, so let's go break this down then. First, obviously, there has to be, the person has to make or cause a false entry in the business record of an enterprise. So they have to, in essence, when you're looking at the facts of the case, the prosecution is going to be required to prove beyond a reasonable doubt, first of all, that payments were not made for legal services under the retainer agreement.
Yep.
Michael Cohen was a licensed attorney at the time.
He was.
He was acting as an attorney for Trump and I believe potentially for Trump organization.
Yep.
At least for Trump, he was Trump's personal lawyer through the Trump organization. It's interesting because in the allegations they say, well, there was no true retainer agreement.
Yep.
New York does not require attorney fee contracts in every type of case. They only require written contracts in divorce cases and contingency fee cases. So if I wanted to hire you to do legal work, we can have a verbal agreement that this is going to cost $420,000. And if I'm willing to pay it and you're willing to do the work, that could qualify as retainer agreement work.
One of the things that I think is interesting about that, especially with not requiring a written fee agreement, is this is going to turn into, if this goes to trial or any sort of evidentiary hearing, Cohen is going to have to be the one that testifies about that. And normally that's not much of a problem. Lawyers are officers of the court. That's something you take seriously. He's a convicted liar.
Yeah, he's got problems.
That's different. That's not a typical lawyer saying, hey, we had this agreement. This is what I was doing.
I will actually tune in and watch that cross-examination.
Yeah.
Because that's the next element is during the commission of another crime or concealment of another crime. And the other crime is Michael Cohen's federal offense that he pled guilty to, which was excessive campaign contributions. It's funny because it's all tight. When we looked at it, in essence, what they said is, and what he pled guilty to, is by making the payment on candidate Trump's behalf to hush that story, he was advancing an expenditure for the Trump campaign.
Yep.
Therefore, he exceeded $130,000 as well above, I believe it was $2,700 that you could contribute to an individual candidate at the time.
Just a little bit.
Just a little bit.
Not much though.
Felony offense that he's already pled guilty to. That's what they're using as the predicate offense to make this a felony.
I will say I've seen a few things where they potentially are going to try to round it all back to a potential tax evasion too, under New York state law. the $420,000 payment after Cohen made the payment to Stormy Daniels. The $420,000 was calculated to after taxes, to where he would actually be reimbursed with a little bit of a bonus.
It would seem that that wouldn't be tax evasion as much as that would be Cohen's problem, because he's the one that received payment and would then have to claim it on taxes.
That's what I mean. It's all interesting because really it's going to come back to Cohen, as it seems from the statement of facts.
I don't know that I would rest the biggest case of my life and my career as a prosecutor on Michael Cohen on anything.
Oh, the convicted liar. Yeah, no, it's
not going to go well.
No.
And this is the fun part. We're not taking sides. We're saying here's what the charges are. Here's what the law requires them to prove. Here's the hurdles, and here's some defenses.
And this is our biggest hurdle.
And the next hurdle is the biggest hurdle for the prosecutor, and that is the altering of the records has to be done with the intent to defraud. Now that intent to defraud is going to need some lawsplaining, because that's a phrase that apparently even people in the legal community have difficulty with.
Yeah, we can't agree on it. So intent to defraud typically would be intent to steal money, but I think that the definition from what I'm seeing in New York is a little bit more broad. It's money, property rights, or taking something of value.
But if we're lawsplaining,
trying to take something of value.
If we're lawsplaining, it's lying and cheating with the end goal of stealing something from somebody else.
Yes.
That's what that is.
Yes.
I mean, the legal definition, we're in the 8th Circuit, I was in the 8th Circuit, but a lot of the federal circuits use this as well, is to act with the intent to defraud means to act knowingly and with the intent to deceive someone for the purpose of causing some financial loss or loss of property to another, or bringing about some financial gain to oneself or another to the detriment of a third party. When you look at that, that is the most essential element of this offense.
It is.
In other words, so they have to prove that Donald Trump assisted or encouraged or falsified records with, in essence, with the intent to steal something from somebody else. I do not see any way that fits the allegations in this case.
I know.
I am disappointed. Like when they said that they were bringing these charges, I was expecting dirt.
Yeah.
I was expecting something that we had never thought of, heard of, that maybe the feds hadn't got into before they declined to prosecute. But there is going to be a big fat motion to dismiss.
Yeah, there is.
Because in doing the research,
multiple different legal arguments,
all kinds, and they're going to have a lot of merit behind it.
Yeah.
And I think this head prosecutors don't tend to be line trial lawyers. They're politicians with a law degree.
Yeah.
And when you look at this case,
scary.
It's scary, because anytime we start using criminal prosecutions for political gain, we tread on very thin ice, and it starts to erode at really the foundation of government. Maybe there's more that comes of this that we haven't heard about or have no idea. What's the theory?
I have a theory that they're trying to get this New York conviction before they try to do anything else, because wouldn't they be able to use it as bad prior acts?
No.
To show MO?
I don't think they would, unless there was a subsequent conduct that could be charged, because everything is charged from before.
Fair.
So to be able to use this to elevate or make anything worse,
2020,
there would have to be something new.
Yeah.
And we'll see what's going to happen.
Yeah.
The white collar defense lawyers, they go to school on intent to defraud.
Oh yeah, this is
they
speak this language.
They go to intent to defraud college.
Yeah.
Okay, so they know this stuff inside and out, and Trump's defense team they're no slouches.
No.
I think they're going to dig into this. I'm calling it. This thing gets dismissed. This never sees an actual jury trial. This actually gets dismissed before trial, because they can't establish the requisite intent to defraud. That's what I'm going on.
I think you're probably right.
Usually,
Yeah. All right. Well, I guess maybe when they file those briefs, we'll have to deep dive into the legal arguments.
We'll come back and
Trump's team.
See how wrong we were or how right we were.
Perfect.
Right on.
All right.
See you next time.